Professor Carlin, do you agree that we're seeing now a mark, a stamp of the Roberts Court?
I don't think it's possible to do that looking simply at one term, especially because, as both Marcia and Doug pointed out, the court is taking very few cases. This was a term where the court set the table, I think, for a lot of future litigation. In the voter ID case, in the guns case, even in the Guantanamo Bay case, the court didn't fully resolve the issues, and I think those issues are going to be back at the court. And when they come back, I think we'll see the same kinds of divisions and contentiousness that we saw last term, for example, in abortion or in the school desegregation cases.
Professor Carlin, is that a consequence of what you heard Professor Komek talk about, of trying to settle on the narrowest questions and, in effect, almost guarantee that these issues are going to come back in one form or another?
I think it is. For example, in the guns case, all we know from what the Supreme Court decided was that individuals have a right to possess some kinds of weapons under some circumstances in some places at some times. But Justice Scalia's opinion for the court didn't even address a very basic question, which is whether the Second Amendment applies to state and local regulations of firearms. I think it's clear the court will hold that when the issue comes back, but it's going to be a while. The opinion also said, for example, that restrictions on which kinds of people can carry weapons, where they can carry weapons, whether there are licensing restrictions, all of those are still up for grabs. The same thing in the voter ID case. The court didn't say that voter identification laws are always constitutional. It said it would wait to see a so-called as-applied challenge, where a particular voter comes in and says, I wasn't able to vote because I didn't have the identification and I couldn't get it. So I think a lot of these issues are going to be coming back to the court again next term or the term after. I don't think the court has settled these issues in a narrow way.
Professor Komek, do you agree with that analysis, that in effect they're not settling anything because we're going to see these issues in one form or another again?
Well, I think many of them will come back, Ray, but I do think they are settling things in the sense that they're giving general guidance and approval of the legislative work that's coming to them. And I think that's very important for the Supreme Court to, in essence, give deference to the legislative branch as a vindication of democracy. The second thing that I think is important is that when they send these cases back, they're sending them to the lower courts expressing a great deal of confidence in the lower court judges. And you can't always tell what the lower court will do. The Supreme Court last term had a partial birth abortion case, which they upheld the congressional statute on its face. And when it came time for Virginia to consider a parallel statute, they struck it down as applied, almost even though the statutes were relatively close. The fact of the matter is that the method that the court has chosen is a good one. More troubling is in these larger cases, like the gun cases. Many of us, especially from the conservative perspective, had hoped that originalism as a constitutional theory would give us an objective basis to decide these cases. Well, here you had two justices, Justice Scalia, really the strongest proponent of originalism, and Justice Stevens in dissent, both relying upon very close readings of history, very close readings of text, and yet coming to night and day different conclusions. That's troubling that the court has not been able to agree upon a constitutional methodology that in fact gives us some real understanding and certainty of results if we apply that rule consistently from one case to the next.
Professor